All right, good afternoon, everyone. This is Curt and
Brad Pinsky.
All righty, and we are here for another edition of Fire Law Roundup for November 21st of 2022. Brad, take us away.
Well, I was so happy last week to be done with New York State. Like I said, let's get the cases out of New York, but now let's start in New York, and then we'll go back to picking on Texas and LA for a while. We're going to start with a settlement in Buffalo, New York, or we call them like 6 feet under snow. I mean, they have just got destroyed with snow, but this is a different issue. So in New York State, so everybody knows, and this will have ramifications, I think, for everybody. I think there's one or two good points to take away from this. So the first is that in New York State, starting March of 2 years ago, New York State legalized recreational marijuana. Now, that's not this issue before I even tell you what happens. But New York State, before that, had authorized the legal use of marijuana, or cannabis is the right term, cannabis products, for medically authorized or medically certified use. And so our listeners understand, probably in no state is marijuana or cannabis prescribed, because you can't prescribe it, because at the moment it's a controlled one substance. That may all change very soon, maybe. But nonetheless, so medical marijuana is certified. So here's what happened. So here you have a union shop where the city of Buffalo, very busy fire department, they are just running structure fires right and left, having nothing to do with this. But nonetheless, the city of Buffalo is unionized, of course, and they have a collective bargaining agreement. And the CBA predated, I think it was in 16, the CBA predates the legalized use of certified marijuana. Again, I can't stress enough, we're not talking about recreational use marijuana. So everybody in New York or the other 20 some odd states who have legalized marijuana, keep the issues separate. You cannot, I think, Curt, you would agree, you cannot evaluate the marijuana issues in a vacuum. You have to separate recreational use and certified or authorized use. And this is medically authorized or certified use. So we're not going to talk about recreational. So here, a firefighter used it for a condition. It was very clear when he went for a drug test. Listen, here's my card. I'm certified, used it, and they terminate him. And this is a very quick turnaround. So he initially moved to dismiss the case. I have not been able to read that.
The city moved.
I'm sorry. The city, the defendant, moved to dismiss it. The judge denied the motion to dismiss, and now they have settled. So look, on the facts, all that's happened is there's a settlement, and people settle for a lot of reasons, right? Either because we think we might lose, either because we don't want to risk losing, or, hey, we totally admit it, we shouldn't have done it, we're going to lose, so here's a payment. We don't know what that is, but it's a settlement, so there's no real law on this. But let's look at some of their obvious concerns. Some of the obvious concerns are, they argued unsuccessfully, the city argued unsuccessfully that, well, wait a minute, the CBA prohibits certain marijuana or cannabis use. That didn't persuade the court. So I think the biggest takeaway is, if you have a CBA in your local, and it predated your state's authorization of medical marijuana, and almost, not every, but many, isn't it like 29 or 30 some odd states are now allow medically authorized marijuana.
We'll get to this, but there's an interesting nuance, because I would say this is a much more narrow case. Now, you're from New York, so sometimes when you're from a place, you kind of take it for granted. Right. But New York and Connecticut, and I'm not sure our law doesn't quite go as far as yours, but your law is different than most other states in that it basically protects someone from employment discrimination.
It does.
Who has that medical certification.
Right.
Most states that allow medical marijuana don't have that.
Okay, so we definitely do. We have it both in very expansively, and our laws, by the way, were modeled after Colorado, right? The originator of this.
Well, see, again, there's two parts. There's one is the medical marijuana part. Okay. The other is the employment discrimination part.
Okay. Yep.
Okay. And you might have modeled the medical part at it, but you and Connecticut are really way out in front of the rest of the country.
Okay. Well, New York has
are.
a good or bad, a long history, especially recently, of protecting workers' rights from activities. They are clearly here saying it is employment discrimination if you discriminate against somebody. And let's point this out. So notice this is in state court, not federal court. Under federal court, as we know from a case, city of Waterford, isn't it? Not Eckstein, Eckert, or there's a city, I think it's a Connecticut case where they sued in, and it was decided, I believe, in March of 21. I lecture on it. I got it from you, frankly, or from this thing.
It's a firefighter case.
It's a firefighter case.
Okay, yeah. Well, see, you and Connecticut are very similar, but
yeah,
the leading case in this area for most of the other states came out of actually Colorado, and they had medical marijuana. They had a couple of different things, and they legalized marijuana. But the person sued under the ADA. And the court said, wait a minute, it's illegal under federal law. The ADA doesn't give you any protection.
Because it's a controlled one substance.
Because,
right? That's why I think they're in state court as opposed to federal court, because they knew they would lose under the ADA because it's a controlled one substance. Yeah. And, Massachusetts, in a case called Barbados, takes that other view, that I guess what you would say is the majority view, saying, hey, we don't care. Well, no, I'm going to flip that. They take a very protection view of the employee saying, we don't care. It's legalized so many places. We're not going to allow somebody to fire you because you use it for medical use. So they took, and that was back in 17, that case. They take a very employee protected view. New York does the same thing. So under New York's law, they say, we don't care that it's illegal federally. We want you protected for certified use, which again, lawyers drive themselves nuts. I mean, going way back to Gibbons v. Ogden and all these cases where we're saying, wait a minute, interstate commerce, we know this is interstate commerce. The United States Supreme Court held this is interstate commerce. So anything that's interstate commerce is governed and preempted by federal law. And yet states here are like, you know what? We're in charge, not the federal government, which is amazing to me. But nonetheless, all that happened here is they settled in state court under a certified medical use. But I think they didn't want to challenge, because I would like to, how federal law doesn't preempt when state law says, right, it's legal and federal law says illegal, how state law grants you rights that federal law took away. Nobody wants to address that. The United States Supreme Court should address it. It doesn't seem to be getting anywhere, even progressing through the appeals courts. I don't think anyone has said anything. Instead, what's tactically going to happen, just for everybody understanding under marijuana, there are three important things that are happening federally, which is going to make it easier for lawyers, not easier for employers. The Biden administration is decriminalizing marijuana. That doesn't affect the employers, but it's always step one. We decriminalize marijuana. Every state has gone that path that eventually legalized it. The second is the MORE Act, which is in the House of Representatives, to remove, basically it would remove, order the FDA and the ATF from, it would force them to remove actually DEA and FDA to remove marijuana from the controlled one substances list. And the third thing, which I just saw might happen, though it's going to be very tough if we cross January 1st with the new House, they are trying to get the what's called Safe Banking Act, where they can allow banks to utilize money derived from the sale of marijuana. Right now, it's got to be cash transactions or otherwise. So those three things are moving towards the legalization of marijuana at the federal level, which will make this easier. Right now, what we're seeing is exactly in New York. Hey, we're going to sue in state court, stay out of federal court, because we know that's not going to go well for the employee, that they'll be employer sensitive. And we're going to use New York State's law, which is clearly preempted by federal law, but no one seems to care at the moment. And that's where we are. So I think, as you said, every state is maybe in somewhat different in many ways. New York, Connecticut, and I think Massachusetts may be in the minorities. So you can't expand this too much, But I think one big point is with your CBA, you better look to see what your state law has done with regard to medical marijuana and make sure your CBA is updated after the date of that law to reiterate what you want. And I think most unions and employers want marijuana use made impermissible.
Yeah, and I understand how things like that can get overlooked. The gray hair I have in my mustache is primarily due to union-related activities and negotiating and that kind of thing, and strategizing. And one of the challenges is you go into a negotiation and you have certain priorities, and fixing language that might have been in the contract for 20 years is just not a priority. Like, you're trying to get a raise, you're trying to get this, you're trying to get that, maybe some pension and healthcare, and the city's got their issues. Yep. And nobody wants to give up anything just to straighten out some language. And so it's easier, especially as contentious as contracts can be, nobody wants to address it. And now you find yourself with language that is outdated, and now it's creating a problem. And so I understand exactly how it can happen, but it's something that needs to be addressed, like you suggest.
And that's the lesson from this case. But I want to be clear for everyone saying, oh my God, how can you allow marijuana on duty? This is not on duty. This is not recreational. And I didn't mention this. He was very clear. I do not use on duty. I'm replacing another drug which has worse effects while I'm off duty, so I replace it with marijuana. I do not use marijuana on duty. He's very clear about that. So this isn't necessarily a direct safety issue of on-duty use for any purpose. So, but marijuana is going to change this year or not. We're going to find out. We'll see what the Republicans will allow to happen out of the House. So we'll see.
All right.
Oh. Okay, let's go to Texas. This is just another, this was updated, but this is just another theft case. Thieves, alleged thieves, no boundaries. But here we have a chief who has now been indicted by a federal grand jury, 13 counts. And they're basically theft and or bribery. That's the more concerning one, frankly. But he was charged with 5 counts of theft or embezzlement from an employee benefit plan. Don't mess with pension funds. If you're going to steal money, that is not the place to do it, because you will bring in the federal government. You mess with what's called ERISA money and pension money, and you're in a lot of trouble. In any event, and he also was charged with 5 counts of making false statement. He was allegedly planning to retire, or maybe has retired. I don't know why there's some dispute about whether he has or has not retired. But in any event, he is indicted for, again, innocent till proven guilty, for stealing pension funds. There was a little more to this, because allegedly this whole thing came out of another lawsuit where another I think firefighter had accused him of trying to retaliate against that firefighter because he was, quote, asking too many questions about the 401k plan. Listen, just as a heads up, when you want to audit somebody or get some information on anything financial and they tell you to go pound salt, that person's probably stealing, right? Honest people don't mind being looked into. But again, just allegations. We don't know anything more than an indictment. In any event, this started to get unraveled when people started asking questions. And that really is my point of highlighting this case, because asking questions is important. And that means internal audits. That means somebody's looking at the bank statement. Somebody's looking at all the checks being cut. All it takes to make a thief or an alleged thief uncomfortable is asking questions. So you should be auditing, internal auditing, asking questions, and nobody honest should be saying you don't deserve the answers. So that's, short little set of facts, but there is something to be learned from it. Yeah. Okay, let's go to Los Angeles. I'm much more comfortable with, suits in Los Angeles. I don't know how I feel about
shortage
this,
of them.
I think this is a local thing. So look, it's a simple, it's not the simplest set of facts. We've seen this same type of accusation, but this is a lot. There's 2 parts of the accusation. So let me give you the best overview of the most pertinent facts that I can do. So a man goes to the bank, right? I don't know whether he's homeless or not, but he's going to the bank. He's trying to do a transaction. As he's doing this transaction at the bank, he said he's having chest pains and feeling lightheaded. And so he lays down in the bank, but still says, hey, keep processing the transaction while you're calling 911. Very dedicated banker, let me tell you. So the ambulance comes, they take him out to the ambulance, and they are very demanding, saying, we are taking you to the hospital.
And he's very upset. He's very upset that he's not allowed to continue his banking transaction while he's having chest pains and difficulty breathing. So
right. So he wants to delay it.
I want to include all that in there because we deal with this kind of nonsense all the time. So
yeah, but we do. And it's funny because there's a civil rights part of this, which we'll talk about, because last week we learned he probably is going to lose, but if the last week's case applies, but nonetheless, we'll talk about that. So here, right, he's claiming then that they took him to the wrong hospital he didn't want to go to. His medical records were somewhere else, is kind of claim one. Despite, hey, he was telling the paramedics, go get my bank card, don't take me yet, whatever. He talks about them being very demanding. He's going to the hospital. I'm like, yeah, because you're having a heart attack. We're going to demand you go to the hospital. Let's, forget about your damn bank card. It ain't going anywhere. It's with the tellers or whatever. Let's get you to the hospital. So they claim, hey, my medical records were somewhere else and you took me to a different hospital. I don't personally have a problem with that. You're going to the closest appropriate medical facility. All right. They'll get your medical records. They're all online between the hospitals. I'm sure they'll get them. So then they claim that he's getting very active, very vocal, very whatever. And they keep telling, allegedly, these are all allegations, by the way. Let me be clear. This is just out of the complaint. There's no court finding. These are just allegations, but a lot of them you could see as true and defend the paramedics on them. Like, no, we're taking you to the closest hospital. But they said, he said that they gave him a drug to calm him down or for some purpose. This guy claims he actually has a master's. I'm sure he does in some chemical related science. So he was familiar with the drugs they wanted to give him. He said, listen, I have an allergy. You can't give me certain drugs. Apparently he's having a STEMI, which our paramedics will know, but he's having a heart-related incident. They give him a drug. And here I get a little confused, frankly, at what actually happened. But he allegedly, the drug he's given to, I can't tell if he's claiming he's allergic to that one or not. But later he wakes up in the hospital having some, I don't know if it's paralysis or whatever, but he said they gave me a drug that caused him, I think it's paralysis, some paralysis, localized. And I'm guessing he's also suing the hospital, but he's basically saying you gave me Haldol or something else, which I shouldn't have. You didn't treat my heart attack, I believe is what he's saying. It's a little confusing to me anyway, reading this. And he said, you caused me injuries for all these things. You gave me a drug I didn't want. You gave me a drug maybe I was allergic to. You took me to the wrong hospital. And the hospital, I think, must have done something. And you didn't document my chart properly. You didn't treat my heart attack properly. And you're liable for my injuries. So now we have a negligence case that'll go on forever. I don't think anyone's going to settle this case. And the hospital will never really jump in and say that's not what happened. But that's where we are, just an accusation. This is not but I want to comment on something important because he in his complaint, he sues for civil rights violations. And I think it was last week when we said a court threw out civil rights violations, saying unless you had an affirmative duty to act, saying to the paramedics, unless you were obligated by law to act and provide ambulance treatment, the fact that you responded and provided it, even as part of the fire department, is not enough to violate your civil rights. Here, if I'm them, I'm moving to dismiss the civil rights and other claims based on that case from last week, saying, well, wait a minute, this is the exact same facts, right? We didn't have the obligation to respond. And everything we did was discretionary. And frankly, everything they did probably was discretionary, what drug to give, et cetera. So as a civil rights violation, that may get thrown out. And attorneys for this case, if you're watching us, you should go look at last week's video.
Yeah, he's pro se. He's pro se.
Oh, is he pro se?
Yeah.
Oh, that's probably why I didn't understand half the complaint.
Yeah, well, exactly. And I think there's a couple, you brought up a really good point. I hadn't thought about it, that really there's two parts to this. There really is that first part, which I think is the kind of nonsense we constantly seem to deal with somebody who's claiming to be ill, claiming to have chest pains, difficulty breathing, but they still want to go through their transaction at the bank, and they're lying under the table, and like all that drama kind of stuff. Okay.
Right.
So, but what can happen then is that initial impression of the patient as being some sort of a problem person then can cause you to maybe not treat the person properly, not consider what they're saying about their allergies and some of the other things. And now you end up in a situation where he's claiming that he's got some sort of kidney failure that is associated with the, let me see if I can get it right.
Was it Haldol, Versed, or something else?
Yeah, well, something that he was given, and he was then unconscious once they gave it to him. But it's called, I'm going to butcher this one, rhabdomyolysis, rhabdomyolysis, whatever. Yeah. And but he's got a serious form of muscle damage and acute kidney injury. So, you wonder if his initial impression as somebody who's just claiming one thing but behaving in a different way might have caused some of his course of treatment to go the way it ended up going.
If it's true,
again, absolutely, if it's true. Right. But if he was indeed allergic to it and he told the medics, don't give me that, and they gave it to him anyway, that's certainly going to be a problem. Now, the plaintiff's problem here is that it looks like he did a pretty good job for a pro se plaintiff. He did a pretty good job of making his factual allegations, but he's missing about 10 pages in the complaint to properly make your allegations of negligence, malpractice, certainly those civil rights allegations and so on. So he kind of, my concern is this is going to be dismissed based on the failure to plead it properly.
And you got to imagine he went to some law firms, and the law firms looked at him or his case and said, no.
I would think so. And I find that hard to believe, especially in a big metropolitan area like LA with folks that advertise and they'll take slip and falls and they'll take virtually anything.
Right.
I do. But, that may also explain maybe, some of his behavior at the beginning of this, because I think if we separate the beginning and how the first impression went with this person and then his subsequent treatment, maybe that explains, maybe his behavior explains why the medics treated him the way they did, and maybe why he can't find an attorney to represent him. I don't know.
Or maybe the medics didn't treat him that way and they treated him.
That's true too. Yeah, absolutely. And maybe, I know people don't believe this, but attorneys are under an obligation of due diligence to research before they file a lawsuit. A person can't just come in and make these allegations and you file a lawsuit. We can be sanctioned and disciplined. So they've got to do some research. And maybe when they actually get the reports, maybe they didn't feel comfortable pursuing it. So, but interesting set of allegations. And, I guess his initial explanation of what happened at the bank just brought me back to so many different runs I've been on where you just have somebody who's, really having chest pains, but you want to continue with the bank. Make up your mind. Either it is serious and we're holding up an EMS unit for you, or it's really not all that serious. So,
and who knows? He could be. I mean, we just don't know. But in any event, we don't. The city, look, and there's all sorts of notice of claim requirements they may have missed. They may have missed filing deadlines. This may turn into nothing, or it may drag out forever. But very tough for a pro se person to navigate their way through federal court.
Yeah, absolutely.
Okay, let's go to Colorado. I have a hard time understanding this, frankly, but I will. So look, here are the facts, and I'll say why I'm shocked. So a Colorado firefighter who's responding in, I guess, a mini pumper or something, like a wildland SUV type vehicle, is he was responding to a tree stump on fire, which, let's not say that that's nothing, right? Because fire goes through tree roots and can pop up somewhere else. In any event, but it's in Colorado and it's in a park. So I don't know what Colorado's homeless. I know Denver has a big homeless population. I don't know what their parks are like with homeless. I suspect this was a homeless person. In any event, as the driver's driving, he sees a pile of blankets, allegedly, in the park, and he drives over them. He didn't see a body, but apparently he should have known that there was a body underneath, and he runs over a body and he's charged with a misdemeanor for careless driving. Look, if this was in my hometown and you're driving through a park and you ran over a pile of blankets, and a person was under there, you wouldn't think there's homeless people under there. So I don't know, right? It's certainly interesting, but the department, to his credit, has left him on the job. He's a longtime firefighter there. He's not been removed. And I think that's a smart thing to do if I was the lawyer for the city, because what's next coming after the criminal charge is the lawsuit. I'd be saying, listen, we stand by this guy. I don't know. I mean, I throw it out to the viewers. Is it really reasonable in your area to be forced to assume that a pile of blankets has a person underneath? If you're driving through Battery Park in the island in New York City, yeah, you probably should assume there's a lot of homeless. If you're in LA driving down, Ocean Ave or certain avenues and you see a pile of blankets, yeah, don't run over them, probably homeless, right? I don't know in Colorado in this park what it's like, nor whether they should know. Why you would run over an elevated pile of anything kind of blows my mind, but whether that rises to the level of criminal, right? It might be negligent, probably isn't reckless, but again, I don't know their park system.
Yeah. The facts reminded me of three other cases that we've covered, or you and I haven't covered, but I've covered in the blog, and I think are interesting. One, and I forget the state, but it was in fact, I think it was North Carolina. I was in North Carolina, and they had basically a four-wheel drive truck going on a beach for a rescue, and it came over a dune and ran over somebody laying on a blanket. Okay, and there was a question: could they see? They couldn't see, but they ended up coming down on a person who was on a blanket. They had no reason to believe that there was someone on the other side of the dune, but
except that it's a beach.
So that was case number one. Case number two, I don't know if you remember this one. It was was an Air China airplane crash, and
let's not talk about this. I'm getting on a plane in 2 hours, so I don't want to talk about airplane crashes.
No. Well, it was there was a plane crash, and some of the victims were able to get themselves out. One of the foam units drove through the foam and ran over a young girl. That one.
And I think all of these go to: should you have anticipated that there would be people where you ran them over?
And then the third one was Yukon. I don't know if you remember this one, but there was again, factually, there's a couple of different versions of it, but a young gal was out drinking, and like most college students would be on a Friday, Saturday night, whatever. And however, whether somebody left her there or she ended up laying against the apparatus door at the fire station on campus. They had to run at 5 or 6 o'clock in the morning, and they opened the doors, and she apparently kind of slumped in, but they were already in the truck, and they couldn't see. There's, how it goes. They couldn't see down below. Right. And so those three plus this one all kind of raised that question about making sure that the area in front of you is clear.
Right.
And it's in hindsight, after the fact, it's pretty obvious, but I don't know how you manage that in real time.
Right. And I think with all of those, the question should be, should you have reasonably anticipated it? Right. And And look, on a beach.
In hindsight.
Well, of course, yeah.
Right.
Hindsight, I'd win every lottery,
Right.
Anyway, but while we're on Colorado, obviously, Curt and I send our, sympathies and, out for the Colorado Springs shooting. Firefighters know Colorado Springs because we have the memorial out there in Colorado Springs. So firefighters are well used to that area. So horrible thing, but hey, at least people stepped in and subdued the person with his own gun, I guess. Okay, let's move on. Let's see. Is our last one? This is our last one. So we're going to head to, where are we going? California. Hey, we're still in California. And here we have an appeals court. This is a very simple matter. I don't want to make it more than it is necessarily, but here the California Court of Appeals, right? So second court up, I think. Is the Court of Appeals California's highest court?
No, this is California Supreme Court, but there's
second
they
court
have,
up.
They have certiorari. They don't hear a lot of appeals. So
okay. So here they've ruled, so this is actually a court holding for everyone, that it's really two parts. So first they ruled that raising a whistleblower claim where, hey, I brought to the attention of my employer something and they retaliated against me for it, that they could raise that claim for the first time during a disciplinary proceeding, during much later on that. And so people know normally there's this phrase in law, preserved for review, right. And so a lot of times, look, at the beginning of a suit, you've got to say, here are all my issues. And as you go up the appeal chain, as you go through some administrative process to court to the appeal chain, you have to keep preserving those issues. You can't abandon the issues. Well, here he has an issue he raised for the first time later on saying, well, wait a minute, the real reason this is happening is because of whistleblower stuff. So here's what the court does. The court makes two very simple findings. One, they said you can raise whistleblower protections under state law. These are state law protections. There are both federal and state whistleblower protections under all sorts of different laws and regulations. But here the court says, and this is the holding, you can raise it later. But then the court goes on to say, but even though you can raise it, you were terminated for completely different reasons. And everybody who listens weekly remembers that you and I always say the burden shifting from the McDonnell Douglas case. This is basically the same thing, right? This is burden shifting. So the plaintiff says, I think I was fired for an improper reason, and here's why. The court says, okay, based on that, you've said enough that it looks like you've made a case, a prima facie at first glance type of case for discrimination. Now the burden shifts early on. This is before we really get too far in the whole thing. Burden shifts to the employer here to say, no, we had a different unrelated reason to his whistleblower complaint in this case to say, no, we terminate him for something different. And here the employer has satisfied the court that that was indeed the case, that it had nothing to do with the whistleblower issue that we terminated you for. We terminated you for a totally legitimate, non-discriminatory reason. We're allowed to do that. And the court agreed they're allowed to do that. And it's been thrown out. So two holdings, one, not such a big deal, right? That you can raise whistleblower stuff later on because it's kind of a state law specific thing. But the big part, again, to reemphasize the burden shifting, when you take action, you better have a 100% completely unrelated to any discriminatory, intent. You have to have a perfect unrelated reason why you terminate or take action. And if you do, and, you raised the issue, I think on your blog, you said, this happens all the time. People try to, and the court even had some very good reasoning. Let me pull it out from the court. I like what the court said. The court said, this is really good. It's settled law that whistleblower protections extend under state law. But they said, and they come out saying, but it doesn't matter. They had a different reason. But the rationale the court extends is important for everyone to understand here. They said, quote, employers need not suspend previously planned adverse actions upon a plaintiff who's engaging in a protected activity, and they're proceeding along lines previously contemplated, though not yet definitively determined, is no evidence whatsoever of casualty. casualty, causation. And the court says if the rules were otherwise, a plaintiff could orchestrate a retaliation claim by purporting to reveal an unlawful act of a coworker at any time during the disciplinary process. So here's what the court really is offering good advice to all of you watching, which is, listen, just because somebody comes up with a threatened, oh, you're discriminating against me, and throws out it's based on race, religion, gender, whatever. If you took your initial actions based on non-discriminatory reasons, right? He just was violating our policies and nothing more. The court is saying, keep going on that. Don't stop your process just because he's now raising discriminatory allegations, as long as, again, you were originally only proceeding on non-discriminatory bases, right? You violated our policies. Just because someone says, yeah, I may have violated your policies, but I'm also a protected class, right? Black, Jewish, gay, whatever. The court says, keep going. If you're clean, you're clean. And I think that rationale is really good. And the court says, look, otherwise everybody would derail their processes as soon as somebody raised a discrimination claim. Well, and you shouldn't do that. And we would, as lawyers, say don't do that.
There's an interesting factual thread through this that I think it can come up. You don't see it very often, but you have a firefighter, and I understand he had some sort of an altercation with his brother off duty. As I'm reading it, it assumes that it was some sort of an off duty. They were both firefighters, and there was a time delay. But the bottom line is the firefighter is being disciplined now for something that happened previously off duty. Part of the firefighter's defense at his disciplinary proceeding was that his brother was lying about being as injured as he actually was, and that he was engaging. I think the firefighter who was accused of misconduct, Captain Olguin, was alleging that his brother, who was the victim of the assault, I guess, wasn't as badly injured as he was committing insurance fraud as part of an attack on his credibility. And
very close family, apparently.
Well, I guess, but that was what he was blowing the whistle about. So that comes out at the disciplinary hearing. Now, the captain had said that prior to the discipline hearing, the chief had assured him he would not be fired. And so then he ends up going through the hearing, getting fired. And what he argued was that because he accused his brother, because he outed his brother for this insurance fraud scheme, that he was being retaliated against, that they escalated the discipline from what they were going to give him to termination. So that was where the whistleblower part of this came in. He said, basically, I blew the whistle at the disciplinary hearing, and the city tried to argue, like you were suggesting, it's too late. You should have raised that earlier his point was it hadn't happened yet. How can I submit a defense when it hasn't happened yet? I didn't know you were going to retaliate until I was terminated. So the court dealt with that. And I think that there is some very good language in there. And the court raises that question. I mean, you put the person in the situation, how can they anticipate a defense before the act of retaliation actually happens? So they said, no, you can raise the whistleblower defense at a later point, but factually, the chief may have made you a promise. The chief wasn't the decision maker, and I forget who it was. The city manager.
They said the city terminated you.
Right. So the city manager was. So, and the city wasn't bound by the chief's assurance that he wouldn't have been terminated. So they found, based on the facts, there was no retaliation. There was no binding promise not to terminate, and so there was no retaliation.
Yeah, last week I had ended, as we're at close to the end. Last week I ended by saying, there's a lot of professional responsibility or professional lessons to be taken, right, from everything we discussed. And I suggested that fire departments should give their chiefs and lieutenants and everybody watching some credit, some training credit, because you really get a lot of good stuff out of this, as we reiterate McDonnell Douglas and burden shifting and things like this. And, these life lessons, oh my God, what do you do if somebody's now claiming discrimination? I think there's right, here's the court's answer. Well, if it's legitimate that you're terminating them for non-discriminatory reasons, keep going. So that's these types of nuggets, so to speak, that people get watching repeatedly, because you'll start seeing themes, I think are very important for our viewers. And that's what these cases give you. The facts are not as important as the lessons, so to speak, to be taken to our viewers.
Certainly.
So that's it.
All right. Well, Thanksgiving week is coming up, Brad. So you guys, where are you spending Thanksgiving?
We are leaving for Florida to see parents and in-laws. So we're headed out. Don't rob our house if you're watching this. We have big dogs. So we're taking off to Florida in just a couple of hours, and then we'll be back next week.
Excellent. Excellent. All right. Well, that'll do it for another edition of Fire Law Roundup. Please, if you haven't already, please, click like, subscribe, and share, and, please help us. We're trying to grow to 1,000 subscribers. So whatever you can do to help us get there would be very much appreciated. And that'll do it for another edition of Fire Law Roundup.